Last week, Bank Hapoalim admitted to committing two different federal crimes. First, it admitted that it conspired with U.S. taxpayers to hide assets and income in offshore bank accounts, and it agreed to pay nearly $875 million to resolve those charges. Second, it admitted that it conspired with sports marketing executives to facilitate the payment of bribes and kickbacks to soccer officials at FIFA and other organizations. So today I'm going to talk about what exactly the bank admitted that it did and what banks operating in the United States can do to avoid paying these types of penalties in the future. The bank has admitted that it conspired to hide more than $7.6 billion in assets in Israeli and Swiss bank accounts. And most of the wrongdoing occurred at a Swiss financial institution that is a subsidiary of Bank Hapoalim, which is the largest bank in Israel. The wrongdoing consisted essentially of hiding the identity of the U.S. taxpayers that were putting their money into the bank accounts to avoid paying the IRS here in the United States. And the core wrongdoing was allowing them to use false forms of identification. So they'd be U.S. residents and they were allowed to use non-U.S. forms of identification. And similarly, they allowed the U.S. residents to open accounts using code names or pseudonyms. And in calculating the amount of the award, the Department of Justice emphasized that it was focused on the involvement of people at high levels at the bank. So this included senior executives and even members of the board of the Swiss entity that opened the accounts for these individuals. And the Department of Justice noted that the agreement did not waive criminal liability for those individuals. So we may yet see criminal charges brought against some of the individuals who were employed at the bank and were involved in this activity. The bank also admitted that it conspired to launder over $20 million in bribes and kickbacks that were paid to soccer officials, both at FIFA and other organizations. And essentially what happened is there was a sports marketing company that wanted to broadcast soccer games, and that marketing company paid bribes to individuals both at FIFA and some of the other soccer organizations in order to win the right to broadcast those games. While those payments were being made through the bank, compliance officers at the bank identified that there might be red flags here, and they wanted to follow up on the transactions. But instead of following up on the transactions and preventing them, the bank continued to pay them for years. And in calculating the appropriate penalty level for the bank, the Department of Justice again focused on the involvement of individuals at the bank. And some of the evidence of wrongdoing was pretty overwhelming. So for example, there's one phone call that is quoted where there is an employee of the bank that actually refers to the payments as bribes and talks about money laundering, and even talks about the fact that some phone calls were being wiretapped. And ironically, that phone call was itself being recorded. So I wouldn't be at all surprised if we see criminal prosecution of some of these individuals in the future. In reading about a case like this, it is easy to say, how do you stay out of trouble? Don't commit a crime. But it's not that easy, because banks have employees, and some employees are going to be tempted to engage in wrongdoing. So what can a bank do to minimize the risk of having employees that engage in this kind of wrongdoing, and to reduce the risk of having to pay financial penalties if employees do engage in this kind of wrongdoing? The key clues in how best to address this can be found in the settlement materials drafted by the Department of Justice. Because if you see what they focused on, you see what led them to both bring these cases and to seek significant penalties against the bank. One is the level of involvement. So we've seen case after case where very senior people at the bank, and here this included members of the board of the Swiss financial institution, were involved. And that's always a red flag. If you have a board member or a CEO who is involved in individual bank accounts of high net worth individuals and approving activity within those accounts that is being questioned by compliance officers, that's always a bad sign. A second issue is in cases like this, when a compliance officer identifies red flags and then those red flags get shut down and the investigation is terminated without documentation as to exactly why the compliance officer's questions were never answered and why the transactions were processed. So it is critical, once a red flag has been identified, to always document why that question did not result in the transaction being stopped. So that leads to a general piece of advice here, which is that as a financial institution, it is critical that you be aware of the possibility that very historic transactions can lead to penalties. Because here we have conspiracies that began in 2002 and in 2010. And that's one reason why documentation is so important, because it's difficult for a financial institution now looking back to determine why it made the decisions that it made. And if you as a financial institution are concerned that some of your past transactions may lead to government scrutiny, you should look into it and you should consult with counsel. And good news, I'm a lawyer. So if you have questions about whether you have any legal liability about past decisions that were made both by compliance officers or by executives at the bank, feel free to give me a call. I'd love to talk to you about it.